ready, Judge?
All rise, yes.
All rise.
All right, everyone have a seat. We're back on the record for State of Florida versus Tracy Nicks, CF 22-289. Members of the jury, did y'all reach a verdict?
This is the moment every courtroom watches in complete silence. The jury has reached a verdict. Months, sometimes years, of investigation, testimony, and arguments are about to be distilled into a few sentences. Before we hear it, what's your prediction? Guilty, not guilty, or a mixed verdict?
Who's if my foreperson would raise their hand and hand the verdict to the bailiff. All right, defense, please rise. Mrs. Nicks, please rise. All right, we're going to go ahead and publish the verdict.
In the Circuit Court of the 10th Judicial Circuit of Florida in and for Hardy County, State of Florida versus Tracy Howard Nicks, case number CF 22-000-A000-XXW, verdict form. We, the jury, find as follows as to count one of the charge. The defendant, Tracy Howard Nicks, is not guilty.
That's a split verdict. The jury rejected one charge, but convicted on another. Mixed verdicts aren't unusual. They often show jurors carefully evaluated each count separately instead of treating the entire case as all or nothing. It's a reminder that every charge has to stand on its own evidence.
We, the jury, find as follows as to count two of the charge. The defendant, Tracy Howard Nicks, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Don't read anymore.
Yes, sir.
All right, thank you. Mr. Fletcher, you wish the jury to be polled?
No, Your Honor.
State, you wish the jury to be polled?
No, Your Honor.
I'm going to release the jury.
No objection.
All right, all rise. Members of the jury, I want to give you your final instruction. Hold on one second. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors, such as yourself. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might...
Notice how the jury's role is now over. From this point forward, the focus shifts entirely to the judge. The next decisions aren't about guilt anymore. They're about what happens to the defendant while awaiting sentencing.
Seek to find fault with you from the media, from the attorneys, and elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I want to thank you on behalf of the citizens of Hardy County and Polk County for spending your time with us. Thank you very much for your time and consideration. You may be excused.
Even note.
All right, all once they leave, have a seat, and I'll have the defendant proceed to the podium with their attorney. Okay.
Once here.
Right there. Okay. Ms. Nicks, stand next to your attorney, Mr. Fletcher. Everyone can have a seat. Mr. Fletcher, Tracy Nicks, having been found guilty by a jury as to the charge of leaving the child unattended in the vehicle for more than 15 minutes, contained in case number CF 22-289, I now find you to be guilty of the offense. State, what's your position on remand or bond?
Your Honor, she's been convicted at this point. I would ask that...
Here's an important legal battle that often gets overlooked. The defense isn't arguing innocence anymore. They're arguing for freedom before sentencing, and signaling they'll seek a sentence below the recommended guidelines. That can have a major impact on the final outcome.
Defense position on remand or bond.
Your Honor, I request that she be allowed to be out on bond until we have a sentencing hearing. Will be requesting a less than guideline sentence. I will request, based on my experts, that you partially heard that.
And there's the ruling.
Based on my experts,
even though the defense emphasized years of compliance while out on bond, the judge orders immediate custody and revokes bond. A guilty verdict can dramatically change the court's assessment of pre-sentencing release. Do you think this decision was expected?
Her sentence be below guidelines. I have also had my office contact the bail bondsman. He is willing to remain on the bond. I can tell you that as an officer of the court. There's plenty of time to incarcerate her. I do need her also to be able to prepare for sentencing.
All right, state anything further?
And further, Judge, she's been on pretrial release for over 2 years. There hadn't been a second's problem with her. She's been to every court appearance that we've had, and I see no reason to remand her at this time.
State anything further?
No, the state stands by its previous position.
All right, a sentencing date of April 3rd at 8:30 a.m. Does that work with state?
We will make it work.
Defense, does that work with defense?
Same as the state will make it work.
All right. At this point in time, based upon the jury verdict of guilty, I'm remanding you into custody, Ms. Nicks.
With the trial now over, the next chapter is sentencing, and that's where both sides will present arguments that could shape the defendant's future. A conviction answers the question of guilt, but the sentence determines the real-world consequences. What sentence do you think the court should impose based on what you've seen?
You are to be with the sheriff pending the pre-sentence investigation report by the Florida Parole and Probation Commission. Your bond is hereby revoked. You will be held at no bond. I hereby order the Florida Parole and Probation Commission to prepare a pre-sentence investigation report upon the defendant and furnish same to the court as soon as practicable. You will appear April 3rd, 2025 in the Hardy County Courthouse at 8:30 a.m. I've set aside a full day for the sentencing. I'd ask the defense and the state to be prepared to present their arguments and testimony that they feel is appropriate to have this court sentence Ms. Nicks in accordance with this verdict. Anything further, state?
Nothing further, Your Honor.
Anything further, defense?
No, Your Honor.
All right, all rise. I'm going to get off the bench. Come on outside.
No, he does not want to be outside. I think just let your man do.
All right, ladies and gentlemen, court is adjourned. Everybody can exit the courtroom now, please. Thank you. You can have it. You're going to finish your file? This judge is aware?
Yeah, you can run it up the cut.
I'm coming to the back.